And I would like briefly to introduce our speaker, Shauna Knippel, who is a lawyer with Murphy Desmond Lawyers. They have offices in Madison and Janesville, and Shauna is a lawyer in the Janesville office. She has her education from the University of Wisconsin. She went to University of Whitewater as an undergraduate and to the law school here in Madison for her law degree. She specializes in a whole bunch of things, estate planning and probate, divorce and family law, and so forth. You will recall about a year and a half, gave us an absolutely wonderful seminar, lucid, wise, on powers of attorney and all of the issues that are attached to powers of attorney. And the Committee on Financial Matters and Retirement has begun to think about what do you have to tell your family and your executor other than just giving them a copy of your will. How do you communicate with the people who are going to have to deal with your estate after you're gone? And we asked Shauna if she would come and give us a talk on that topic, and we were delighted that she said yes. So I am pleased to welcome her here today to talk on that subject.
Good morning, and thank you for having me. I am very pleased to be here. It's an honor. I had a great time the last time I was able to present, so I'm hoping today is just as wonderful. If any of you remember, I do this kind of informally. My goal is to educate as much as possible. A lot of what I say today is going to be very commonsensical. I almost guarantee that everything I say, there's not going to be anything you're like, oh, I never thought of that, or man, that's just incredible information. Now, I do hope it is incredible information, and I think it'll be very applicable to your life, but a lot of it is just common sense. A lot of it will make sense to you. So to digest the information is not going to be hard. What is going to be hard is implementing it. And so the title of the presentation is How to Prepare Your Personal Representative in Your Heirs to Handle Your Estate or to Deal with the Settlement of Your Estate. And I'm going to give you, in some ways, a checklist of things that you need to think about. And again, that's not the hard part. The hard part is the first step where you have to actually go, what do I want to happen? What do I want? What is my plan for when I die? And the reason that that's hard is because it is multi-steps. There's a lot that we have to do and prepare. But the reason I think that it's harder for people is because it forces you to think about your own death. And that can be very hard, not just for us because our mortality is not something that we want. Well, morality too. That's true too. And sometimes in thinking about death and dying, it forces us to think about living. So sometimes that's where morality comes in. But when we think about our death and dying, it forces us to think about, well, what happens when I pass, and my children and my grandchildren and all this life that maybe I wanted to live and I haven't had a chance to. So I will tell you, people avoid it. And that's not unreasonable. I think, I would actually be shocked if there weren't many people in this room here today that this is not the first seminar you've been to, but the third or the fourth or the fifth. And I don't mean that in any way as a criticism. It's because we hear it, we know it to be true, we go, okay, this is what I need to do, but actually going and doing it is hard. And so the first time I realized that, I was doing these smaller seminars in Rock County, in Janesville, and Beloit, and I was working with a group of women who kind of went around and taught kind of a class, and they would bring me in to talk about the legal aspect of it. And I did it the first time, and people would be like, yeah, it's my second time being here. And then a year later, I was back, and the same people were there. And so, like I said, it shocked me the first couple of times, but now I understand in talking to people and having, years worth of clients where this is something that a lot of people are not comfortable dealing with. And when we're not comfortable dealing with it, it's certainly not comfortable for our children to deal with or even our spouses to deal with. And a lot of the the important pieces of our talk today is going to require that you think about it. And it's going to require that you talk to your family about your plans. So those are the critical pieces of it. So again, the information I give you is going to be simple. But I'm not going to believe that sometimes the implementation of the information I give you will be as simple, okay? So a lot of the information is, what do we need to tell our personal representatives and our heirs to begin to prepare them to settle our estate? But the other piece of that is, how do I prepare to be able to tell my family what to do? What steps do I need to take to make it as simple as possible? So I have kind of, you guys were given a handout, which is kind of my outline on how I'm going to go through this. And there's 5 main steps that I would suggest that you do in order to make it as easy as possible for your personal representative and your heirs when you pass away. Because that is the goal here, is to make it as simple as possible for them. And I'll tell you, there's a couple reasons why that should be the goal. First of all, and I'm going to I want to preface this by saying, I'm going to assume that for many of us, I'm going to generalize and assume that it's going to be a child that is taking care of our estate when we pass. It may be, I know, it may not be, and it may be a spouse, okay? It may be a brother, cousin, uncle, no what? But so, you know, a lot of this will apply regardless of who's taking care of your estate, but that's going to kind of be the general premise here, is that, you know, our spouse has passed, or there will come a time when our spouse has passed, and now it's going to be another person who's taking care of our estate, okay? So at the time when we've passed, there's obviously our family's in mourning, and our children are in mourning, and it is very hard for, on top of them to be mourning, to deal with absorbing another person's life, okay? And it is absorbing another person's life. It's the bills and the house, and who mows the lawn, and who cleans the pool, and who takes care of the pets, you know? I mean, it's really just adding the stress of, you know, onto your child, let's say, your grown child who may have children of their own, to now they're acquiring your life, which, as great as that life may be, it is still stressful. And so the common theme that I hear from adult children is they say, I just need this done with. I need to be able to mourn my mom. I need to be able to mourn my dad. Or I need to be able to finally begin to mourn my husband or wife. Because at a time when there is mourning, and then you add all this additional stress, it's hard. You know, it's hard on families, it's hard on everyone. But it's a reality. It's something that has to happen. So the goal here is to make that as simple as possible. And you will notice I have this in number 5. My goal here, or my 5th step, is anticipate conflict, okay? You have to do that. That sounds terrible. And in my line of work, I see all the conflict, and I do realize that many families get through this process without it, but you would be amazed at how many actually conflict is just a natural part of this process. So overall, as we go through these steps, I want that to be in the back of your head. The goal here is to make it as simple as possible and to eliminate or try to reduce the amount of conflict that our children and our families may go through as they handle everything that needs to be handled when you pass away. Make sense? Okay. Any questions thus far? All right, I'll also say that because I do this kind of informally, if there's a question that you have that you think is for the general good, like, Shauna, you just said blah, 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 and I don't know what you mean, raise your hand, okay? Now, if you have a question that's, well, my aunt's cousin, sister's brother's nephew, you know, I inherited something, that's probably going to require a bit more in-depth discussion, so I'll wait around after the discussion, or after the presentation, we'll talk about those, okay? But feel free to pop your hand up at any time. Yes? Okay. Her question was, and we will be getting to it, so I'll touch it then, is we're going to discuss funeral plans, and her question was, she wants to know what are the minimum requirements for the state. I assume you mean we can't burn our bodies on, you know, pyres in the backyard. That is true, you can't do that. You also can't be buried on your own personal property anymore, okay? But I will get to that because there are some minimum requirements. Okay, so step number 1, the first thing you have to do is you have to decide what happens when you die. And that's funeral, okay, that's your funeral. That's picking a personal representative, but it's also what happens to your stuff. What happens to your house? Who's going to inherit if there's anything left? And I'll tell you, my number 1 advice to you is spend it. Spend it all. Take a trip, go to Vegas, take a vacation, live life now, okay? So it's your money. You worked hard for it, so enjoy it, is my number one piece of advice. But you have to decide what happens to all of that. And some of the considerations that you need to think about are, do you want your kids to inherit? And if so, how much? Do you want to leave money for your grandchildren? And if so, in what form? Meaning, do you want to leave college funds? Do you want to leave trust funds? Do you have charities that you want to give to? If you do, you need to start making a plan. And it can be just a general plan. Start scratching some notes on a piece of paper, okay? Start just thinking in broad terms of saying, all right, what do I want to have happen? Because as we go through this and as you think about it, you are going to make changes to that plan, but I want you to start getting a general idea of what you want to happen. Sometimes there are situations in which maybe you have a summer cabin or a home or a family business. Those are also things that are going to require special consideration. Do you have a plan in place as to who's going to run your business when you pass, okay? We call that succession planning when it comes to businesses. You need to think the same thing as it comes to the rest of your life. If you have a family farm, you need to have a plan in place, okay? So that's the first goal. And I'm making the assumption that many of you, because you're here, have started to think those thoughts, okay? And that's good. So start to put pencil to paper, start to make notes, start to get a general idea of what you want to see happen. And I'll also tell you this, there's no right or wrong. Okay, I'm telling you, spend all your money. All right, maybe that's right, maybe that's wrong for you. Your children may be saying, no, save that. Your financial advisor is going to say, oh no, invest it because there may be nursing home costs in your future, and that's true too. So, there's no right or wrong. It's a very personal decision, and I'm going to hopefully kind of give you some pointers, but again, it's what you want to have happen. Talk to your spouse, talk to, friends, whatever, but just get it, not for legal advice. I'm going to give you that one caveat. Don't talk to your neighbor who's like the insurance man about the business advice, and I think I told you that with powers of attorney as well. But just get a general idea, okay? And then the other thing you need to do is pick a person to be your personal representative. Assuming most of you know what that is, I won't go into too much detail, but the personal representative is the person that you nominate or choose to handle your affairs. And like I said, it runs the gambit of what it can be. It's the selling the house, it's cleaning the house, it's getting rid of your personal possessions when you pass away. It's hiring the attorney to give the help, if they need the legal help to go through probate. It really is, it's paying the bills and opening the bank account. It's dealing with, yes, sir. Okay, great question. Personal representatives is the person that handles your affairs after you pass away. Powers of attorney are people who you nominate to handle your affairs while you're living, but unable to make those decisions. So powers of attorney, which I hope you all have, those are only good during your lifetime. They expire or are invalidated upon your death. So you can kind of think about it, if it makes sense. A power of attorney has all the powers while you're living, and then it stops, and the personal representative kind of picks up right where the power of attorney could have left off, okay? So that's a great question, and thank you. So also in Illinois, they're called an executor. In other places too, it's the same thing. It's just the person who is responsible to take care of everything that has to happen in your life. And that's financially, that's filing any taxes, doing any, final things financially that have to be done, but also just the practical stuff. Who takes care of the animals, who sends the thank you letters after the funeral, that type of thing. What I will tell you is pick this person wisely, okay? And it's often a spouse, and then if not the spouse, it's the child, except for this situation. But that's your most common scenario. And pick the child who you think is going to be able to handle this stress the best, okay? Because it really is about, is this person going to be able to manage my affairs when I'm gone? And that's just a responsible decision that you have to make. And you will also, my other theme that's going to come across here is you need to communicate your decisions once they're made. So in the back of your head, whoever you've picked, you need to be prepared to sit that person down and have a real in-depth conversation of saying, I've chosen you to be my personal representative. Are you willing to do that? Do you think you're able to handle that? Because the child, let's just say by example, that you pick, who you think would be best suited to do it may say, Mom, Dad, I don't want to do it. I don't want anything to do with that. So it's important that once you think you have your person picked out, have that discussion with them to ensure that they'd want to do it. The other thing is, let's talk about funerals, because again, that's going to be the very first thing that happens when you pass away, is somebody is going to start making funeral plans for you. And so it's important for you to communicate with your family. Do you want to be cremated? Average cost of a cremation right now is about $6,000, okay? $4,500 on the low end. But I have a friend who's a funeral director in Beloit, and he just very candidly said, most funeral directors are trying to find a way to upcharge cremations because they know that people are going towards cremations rather than burials. So the money they lose on the burial, they're trying to find a way to upcharge the cremation. So in 5 years, expect that number to be increased, okay? Average cost of a burial is about $12,000, and that's expected to increase to over $16,000 in the next couple of years. So, you know, if you want a burial, if you want to be cremated, those are decisions that you have to communicate ahead of time, because otherwise people are not going to know. And I'll tell you, when I say anticipate conflict, you would be amazed at how many times children are like, no, Mom wanted to be buried. No, Mom wanted to be cremated. Well, she told me last week. She told me last month. So, I mean, I'm just telling you, this is real life. And like I said, unfortunately, I see it at the back end. I see it at the worst. And so let's just hope, you know, that's where I'm trying to give you some tips here to eliminate that. But as it relates to also cremation and burials, the urn you want, the casket you want, if you have preferences. They don't have pine boxes really anymore, you know, and so which funeral home do you want to use? Which cemetery do you want to be buried at? Do you want a luncheon in the church basement afterwards? Do you want the luncheon to be at your home? What flowers do you want? What songs do you want to sing? I mean, do you want hymns? Do you want, you know, whatever it is you want? The more decisions that you can make while you're living, the fewer decisions those who are left behind have to make in your stead. And I'll tell you, and if they don't know, they're going to be guessing. They're going to be hoping it's the right choice. And I know it sounds silly, but our family that's left behind, they worry about those things. Well, I don't know if Dad wanted that song. What if, you know, I mean, his favorite hymn was this song. And again, that's where the squabbling comes into play. And it's not because everyone who's left behind are terrible people. It's because they're mourning and they're going through a time in their life of grief and they don't know how to handle it. And so again, the more decisions that you can make for them, the better it is. Now, some of you, I understand, may not have very strong preferences, and that's okay too. But if you do have strong preferences, let them be known, okay? And there's a couple ways you can do this. We were actually talking right before the program, the Living Ledger that the association has, there's a couple worksheets right in that publication that'll walk you through some of that decision making. You could go to any funeral home in, you know, the tri-state area and ask for a worksheet, and they're typically like a tri-fold brochure that'll walk you through what flowers, what songs, you know, what casket, all of that. So you can kind of work out all the details by using one of those worksheets. You could go online or go to the Wisconsin Department of Health and Human Services, and they actually have an entire document in there that you spell out your wishes. A lot of churches have the same thing. So there are a lot of ways to make your wishes known. But again, once you make the decisions, make sure you share that information with somebody, okay? The other thing that I do want to talk about, though, at the time when you pass, the person making those decisions is not necessarily your personal representative. And the reason I say that is a personal representative is somebody that is chosen, or you nominate them, you choose them, but the court actually appoints them. That process can take 30, 60, 90 days after the funeral. Okay, so don't just think, oh, this is my personal representative's job, because you won't have one at that point. okay? So sometimes it's you just get the kids together or the spouse together or your family and you say, here are my wishes, and give them a copy of that sheet. The form through the Department of Health and Human Services, by example, I'll get right to you. Actually, you sign the form. You pick the person who's in charge of making these decisions. You sign it, they sign it. It's an agreement between the two of you, okay? So most of the forms through like the funeral homes and that, they don't actually have that kind of contracted agreement. Okay, so his question was, if you have a living trust, does it spell out your preferences? I will tell you, recently, I've not seen any living trust that has burial instructions in there. That's not to say it can't happen, okay, because living trust, and we'll get to a little bit about the difference between a trust and a will, but a trust is really to determine like your assets, your property. Now again, as an attorney, I could put anything I wanted in there, you know, if I had that preference. Most attorneys don't, though. And the other part of that, and it's the same reason why we don't do it with wills, is when you pass, the funeral is the first thing that has to happen. It is not uncommon for family and friends not to be able to find the trust or the will for months. And so sometimes if you put them in there, you may have had a whole preference, you know, but again, it comes back to communicating your wishes with your family, okay? But so it's not the preference legally to put the burial instructions and stuff in a trust, but it could happen. Yeah, okay. So I'm hoping I'm gonna clarify your question. So in a trust, the person who is responsible for administering the terms of the trust is the trustee or the successor trustee. A personal representative is only appointed by the court if there's a will. Now, oftentimes, or if you don't have a will or a trust. And then that's a process where the court would actually appoint them. And that can, because again, you've not nominated anyone. Thank you. So what'll happen is, if we do it right, if you have a trust, whether it's a revocable or non-revocable, there's always a companion document called a pour-over will that goes along with it. And the pour-over will says, anything that I may have left out of my trust, inadvertently or whatever, we just pour it into the trust. So the personal representative, if there is one at all, their role is very, very limited if you have a trust. So what I would recommend, if any of you in this room have a trust or are contemplating getting one, just make sure if your trustee is the person you want to also make your burial decisions, talk to that person ahead of time, let them know your wishes. Yes. So her question was, you know, why is there really this interruption in the power of somebody to make our burial decisions if you have a POA and then you have a PR nominated? And the reason is because legally, that's all you have is a PR who's nominated. You now have a power of attorney that's terminated because you've passed. And now there's this let's just call it this gray area, all right, between the point where you pass and maybe the court appoints your PR that you've nominated. Nobody in this, you know, from point A to point B has any more legal authority than anyone else to make decisions for you. So that's why it's often just left to the family. You know, and families make these decisions together, or you hope that they do. But that's why if you say, here are my wishes, and then they can carry them out together. That's correct. Her question was, so if you go to the funeral home and you start making decisions and they go, oh, hey, here's my mom's decision, is the funeral home going to go, well, you don't have the right to make that decision? No, they won't say that, because there is no position like a power of attorney or PR that is required in order for somebody to say, these are my mom's wishes. I'll also let you know, though, that if you do fill out that form at the funeral home, they're going to have one on record. Okay, and so that's also kind of a safety net in there. And that brings me to an important part about how to make these plans, because you can make the plans, but then there's a couple ways to prepay for those plans, okay? And so you can either prepay for your service at the funeral home, and they keep that money until the time when you pass, and then, you know, they have to start paying for the casket or the urn or et cetera. And that is one way to do it. So if you have a local funeral home that you know that you want to use, or that you think you're pretty, you're pretty confident that you will use it, you can walk into that funeral home, talk to the funeral director, and and they can help you go through all the steps and all the considerations that you have to think about. And then that money is kept in a trust, the funeral director's trust, until the time when you're going to use it. Okay? The other alternative is what we call a funeral trust, and that's actually an insurance product. And I'll go through why I prefer one or the other. So a funeral trust is an insurance product that you purchase. You can, in the state of Wisconsin right now, the limit is $15,000 per person. And you go and you can talk to certain insurance companies, and you can say, I want to purchase a funeral trust. And then you put the $15,000 into that funeral trust, and its purpose is to do the same thing as if you had prepaid. When you pass, your family, the funeral director is going to submit that bill to the trust, and then they're going to get their check. There's a couple differences, though, even though the purpose of each of these, a funeral trust and then prepaying at the funeral home, the purpose is the same. There's a couple differences. And the major one is that a funeral trust is portable, which means that it can be used at any funeral home in any state, anywhere in the United States. Versus if you go to the local funeral home, that is the funeral home that you will have to use. You have to spend that money there. Okay, so for some of us, as we get older and, maybe we're going to relocate to raise grandchildren in a different state, and maybe that's where we call our new home. Well, if you've already prepaid $15,000 at the, local funeral home, you're going to have to go there. You're going to have to spend that money at that funeral home. So that is a benefit over the funeral trust, is that the funeral trust is portable. The other main benefit to it is that the funeral director never knows how much money you have in that trust. Now this is going to sound cynical, and I don't mean to, but death and dying is a business. Everything is a business these days, and so they have to make money. And if they know that they have $15,000 in their pocket, we all count, we count those eggs before they're hatched, all right? So that's $15,000 that they have. And if now you want to walk in there and you're like, well, it's only going to cost $13,500, I'm pretty confident, I'd bet money that funeral director is going to kind of up your charges. Well, let's add on those flowers. Let's add, let's upcharge this. And because again, they have $15,000. That's what was set aside. Why not spend it all? And more than likely, your family's not in a state of mind to start nickel and diming at that point. You know what I mean? So the reality is probably if $15,000 is prepaid, all $15,000 is going to be spent. Yes. Okay, if you prepay, now technically they should be giving that money back, okay, to your estate, to your family. But like I said, I bet money that doesn't often happen at funeral homes, okay? With a funeral trust, there is greater likelihood of that because, again, the funeral director never knows how much money is in that trust. So what happens is $13,500 is what it costs for the funeral and everything else. They call up the trust. They say, does the trust have, look, I do this as if we still have phones this way. You know what I mean? But anyways, so they call up the funeral or the trust and they say, does the trust have enough money to cover it? And the only thing they're told is yes or no. And then the insurance company will issue a check back to your estate for whatever's left, okay? The other thing I'll say is in the recession of 2008, the Funeral Directors Trust took a huge hit. I want to say they lost about 20% just because of the economy. And so there were millions of dollars that was lost. And they were told by the courts, you need to make good with your clients. So if your clients have lost $2,000, you need to make good and put that money back in. Well, some of them simply couldn't, because you can't get money where there is no money. And so that's where you saw some funeral homes closing, switching hands, things like that. Now, again, the economy is what the economy is, and we all face things like that with the recession. But there are some greater assurances with an insurance product just because of some of the protections that are built in there. So that's kind of the difference between the two. Yes. Oh, I'm going to go to the gentleman behind you first. So I won't get too much into the tax because that is a very scary area. I avoid it. But his question was, are both of those products or both of those, options treated the same for tax purposes? What I can tell you, and I think this is what you're getting at, is both of them are not subject to the look back or to the repayment that requires if you need to have Medicaid. So by example, a lot of people who know that they're going to go into nursing home care, or that's a reality for them, they can divest some of their assets legally by creating a funeral trust. And it is not touchable. It is immediately irrevocable, which means that if you are going to go into a nursing home, because the first thing that happens is they do a financial worksheet with you, okay? And they want to know how you're going to pay. And if you have assets, you are going to have to pay out of pocket until the point where your assets have been dwindled to $2,000 in liquidable assets, okay? You can keep your car, you can keep your wedding ring. Everything else pretty much has to go, all right? So one of the ways that people can legally kind of get rid of some of their money if they have to qualify for Medicaid is to put $15,000 in a funeral trust. Now, if you prepay at the funeral home, I've always been told it's the same thing. Now, so that, at least as it relates to benefits, that's how that works. And it's a good way to do that. I'm just going to get this woman first. Okay, so her question was, do you need an attorney to help you with the funeral trust, or do you go to an insurance company? I actually don't know of any attorneys that do it because it is an insurance product. So call up your insurance agent and say, hi, do you do insurance trust or funeral trust? And it's an application. It's typically a one-page application. The other thing about it is you can take, so by example, it's a non-taxable transfer. If you have a cash value in a life insurance policy that's built up over time, you can transfer that from that cash value from your life insurance policy into the funeral trust. Penny for penny, you don't lose anything. There's no fees, there's no costs. It's just, you're taking money from one pot and putting it in the next pot. And the reason for some people that that's beneficial is because if they do have to go into a nursing home, that money in that life insurance policy is subject to have to pay for your care. Where if you can just transfer it into a funeral trust, especially if you've already kind of earmarked that money for your funeral anyways, which is what a lot of people do, just transfer it from one pot to the next, like I said. Hold on. You had a question? The answer is no. And so her question was, well, if I buy a $6,000 casket today, I want my $6,000 casket 10 years from now, even though it costs $9,000. Unfortunately, neither of those products will protect you from that. And so that is the other thing that you often run across is maybe you put $10,000 down 10 years ago. Well, in 5 years, it's now going to be $16,000. It's going to be $17,000. Yeah, because the cost, everything goes up. So, and there was a question. Yes, ma'am. Okay. Thank you for that wonderful example. So what she said is that when her mother passed away, she left wonderfully detailed plans for them, and that was great. But the one thing that she left out is she didn't tell the family what to do with her ashes after she had been cremated. And now there's some disagreement as to what should happen with those ashes. And so I'm assuming you're kind of at a standstill. Okay. So that's kind of, as it relates to funerals, kind of some things to think about. Now, the other thing I will tell you, and actually this may point to your question, you don't have to be buried or cremated. You can donate your body to science, your entire body, not just your organs, your skin, your eyes. I mean, you can have it as for medical research. And so there's ways to do that as well. If you have powers of attorney, on your medical power of attorney form, on the very last page, it'll say there's a couple lines that you get to check. Do you want to donate some organs, and if so, which ones? And typically, we mean like your liver, your heart, those types of things. You will donate any needed organ or part, which, like I said, includes eyes, skin. And then also, I'm almost positive the very last option on there is I'll donate my body to medical science. So, okay, so that covers the first step. Make a plan, write it down, start to formulate these ideas in your head. Okay, basically a funeral, and then what happens to all of my stuff. Now the next step is probably the most complicated in some ways because it requires you to do a lot of homework, okay? And this is where I think people get overwhelmed and they just quit. Because they don't want to it's hard to get organized, all right? But, so the first thing I would ask that you do in this process of getting organized, and here's why it's important. If you can't find it right now, Your family is not going to find it when you pass, okay? If you don't know what your life insurance policy is right now, they certainly won't know. And I actually had a client once say, well, I found the statement under the rocker in the living room. You know, I mean, it's just sometimes they're buried in boxes, they're buried in file cabinets, they're all over. So some of you in this room probably have things scattered throughout. Some of you probably have a nice little binder in the file folder, in the file cabinet with the label, okay? I want to get all of you to that label, to the file cabinet in a folder. So the first thing I'd ask you to do is make an inventory of all of your physical assets. And now you don't have to include the pots and pans, but you know, think about anything with a value of over $100 if you sold it today. Not what you paid for it, but if you were to have a garage sale or sell it, you know, to a third party, anything valued over $100, make a list of it. And there's a couple reasons to do this. One, if your estate goes through probate, which we'll talk about a little bit, your personal representative is going to have to do this anyways because they have to file an inventory with the court of all of the assets that you had at your death. So make a list. Start to get an idea of anything of value that you have in your home. So this is a good thing just to kind of know. And I mean this like vehicles, electronics, gun collections, sometimes we forget those things, collectibles that are valuable. And I'll tell you the biggest issue that, or the biggest item that people tend to fight over when they disappear are the coin collections. Okay, and maybe because they're just shove a few in your pocket, walk away, I don't know. But, you know, I hear stories all the time of, well, mom and dad, every time they went to the bank, they grabbed a couple coins and they had them in this closet. And, you know, they bought things every year and it was for us kids. And then mom or dad passes and they can't find them. Okay, and that's not because necessarily someone took them, but maybe that's because mom or dad with the surviving spouse sold them and just never told anyone, or they didn't know. So it's a good idea to have a list of your physical assets, okay? Antiques, if they're valuable. So I think I covered, so everyone, that kind of makes sense? Okay, next, you're gonna make an inventory of your non-physical assets, okay? And so what I mean by this are accounts. Yes, ma'am. Thank you for that question. And her question is this. So she's understanding what I'm saying, that it's important to have this list and also a potential value. But she's wondering if to simplify all of this, if we can make a video. And in the age of electronics, yes. Okay. But now how do you store that video? Okay. That's maybe part of it. But yeah, take pictures. Okay. Because that is very important. So absolutely. But I also have to tell you that there is a reason to make a list. Okay, and it's because in Wisconsin law, you are allowed to have what's called a personal property list that designates things that you want to go to certain people. It does not have to be in your will. It's often used as a companion to your will. But what the purpose of it is that if you have a typical will, there's almost always, no matter what law firm you go to, no matter what lawyer you use, or if you just go LegalZoom online, okay? There's always a section in there that say, I instruct my personal representative to look for a personal property list and then to give those items as instructed. And what it is it's normally just, I mean, you can write this up at home. It's just a list of saying, you know, carving from Malaysia acquired in 1972. And then you can say cousin Julie, because you want it to go to cousin Julie. Wedding ring, granddaughter Sophie. Vehicle, who do you want it to go to? So this is your opportunity to, if you know that there are certain physical possessions that you want to pass on to family members or friends, or it doesn't matter who it is, you get to designate that, okay? And so you just put the item, you don't even have to put its value, but you just put the item and you put who it goes to. And this is a valid document so long as it's signed and dated by you. You can change it whenever you want. It doesn't have to be notarized, it doesn't have to be witnessed. This is just your opportunity to make certain gifts of items that maybe you don't want to do it while you're living, but you necessarily want to do it when you pass, okay? So that's sometimes why that list is good, because it can help you do a personal property list. But yeah, pictures are also great. And I have a friend whose father is going to pass soon, and he just has a lung condition, and everyone knows it's going to happen. And so he gathered up all of his children, and they walked through his house, and they put little sticky notes on everything. that's another way to do it. And as long as your family is getting along, that's great, And so we walked by and picked up a statute, MB, because that was the one child. And so again, this is where you have to kind of also know your family. And as long as they're not going to fight, then that's a great way to do it. If you do think they're going to fight, that's where I say anticipate conflict, maybe you do need to make a recording. Maybe you do need to put it in a list, okay? Yes, ma'am. Absolutely. So our question was, if I do this personal property list, are those items separate from the rest of my estate that may get probated? And that's absolutely right, because in the order of a will, and I'm just giving you an example, disposition of property. The first section is going to be, here's my personal property list and here's everything that goes to these people. And then it's whatever is left over after those items are gone, that gets divided equally among my children in equal shares. Okay, so and that's the reason that that's critically important for many families is because what if I'm leaving my coin collection worth $50,000 to one child or a grandchild? What if I'm leaving my heirloom wedding ring to a child and now, but the rest of them think that should be divided up between the three of them? It doesn't work that way. It's everything in the personal property list gets taken out first. Whatever's left gets divided according to the terms of your will. Okay, yes, sir. Okay, so his question was, where do you leave the personal property list? Do you leave it in the lock box? Do you put it in a safety deposit box? I instruct my clients, keep it with your will. Keep all of these vital documents, and we'll get to these a little bit later in our discussion. Keep all of them together, okay? And then have all of these documents that are going to help instruct your personal representative and your family of what to do. Keep them all in the same place. Whoever your personal representative is should have a copy, just like they have a copy of your will, or if you have a trust, your trustee should have a copy of that will. Okay, so your non-physical assets, okay? So we're talking about accounts, whether it's brokerage accounts, mutual funds, investment accounts, retirements, bank accounts, checking, savings, whatever it is, that's the next list you have to make, okay? And we live in an age now being very digital, okay? And so the advice I give you today may be different in 5 years, right? But a lot of times now we have paperless statements. Your bank won't give you a statement unless they charge you $2 a month to get it, right? So we go to these paperless statements. If we have credit cards, we don't get statements anymore. Your investment accounts may only send your statements quarterly, and now if you can opt out of that and maybe, you get some 1%, whatever. But we're definitely in an age where we're going paperless, where everything is digital. And with that, it requires passwords. If you want to get onto that Fidelity account and look at what your balance is, now you need to sign in. Well, 10 years ago, your family looking through your file cabinets or through underneath your rocker, wherever they found it, they would know your account because they have this paper statement. That's not true today. So there has to be a list of your non-physical assets. And I suggest either printing out a recent statement that shows the account number and the balance and either keeping that with it or putting your accounts and password information on there. But now if you're like me, you may forget your password, and now you have to reset it, right? So this is where you really kind of have to be diligent in making sure that you have this most recent information. Or even sometimes, you're required to reset it after how many days. And so, again, there is no perfect solution to this. I just want you to be aware of kind of what you have, and maybe here are some things that you need to consider. Because, again, in 5 years, we're all probably going to get text messages with our information on it, and so it is an ever-changing area in our lives, but just know that if you don't get paper statements, your family's not going to know that you have that savings account at the credit union or at Chase Bank, and so that money's just going to sit there unless somebody knows that they need to look at that place. Yes, ma'am. Okay, so her question is, if, let's say your family knows you have an account at Chase Bank, what happens if they can't get access to it or to know the balance? What legally happens? Well, if you call up Chase Bank and say, my mom has an account here, she passed away, they're going to say, I can't talk to you. Bye. They can't tell you account information. They can't tell you balances. Now, I'm going to tell you that's what legally happens, and that is probably what would happen at Chase Bank. At your local credit union, they may be a little bit more lax and may give you some information, but nobody will have the ability to touch that money unless they're a personal representative or unless you have what we call a POD, which I'll get to in a minute because that is also a very important piece of this. So what happens with all of your accounts typically is once the financial institution knows that you've passed away, they immediately put like a $9 million negative balance in your account. And that just designates to them, listen, no money can come into this account, no money can go out of it. So a lot of times you have Social Security checks that are paid on the 1st of the month, and they're prepaid. Well, somebody's passed on the 17th, no, Social Security doesn't know, they've put the money in, they can't pull that money out without permission, okay? So once the financial institution is notified that you've passed, there is an immediate freeze on your accounts. And they technically should not be giving out any information to anyone, not even your former POA, because the POA terminated, okay? Yes, ma'am. That's what we call a POD, a payable on death. And I am in about like 3 lines down, we're gonna talk in depth about that. No, I'm glad you anticipated it. And what she said is that she recently went to the bank and she signed out a form that left all of her money immediately available to her 3 children. And so that's what we call a payable on death. Yes, sir. Okay, so I want to make sure everyone hears this because I wasn't aware of that either. He said, you know, we've all heard the financial advice of don't use the same password across all of your accounts. I do that occasionally, but you know, don't use that because then if I know your password to your to this account, then I can get into all your other accounts. And there are tools out there, apps, you know, whatever you have, to kind of have like a password manager to where it'll track all of this for you. And what the gentleman said is that there's actually something that you, like I'm assuming a box you can click or you know, like a tool on there that you can share those passwords upon your death, and then you designate who you would share them with. So that is a great manager tool that you can use to manage those passwords. Yes, ma'am. 10 a.m. in this room, April 25th, there will be a presentation just on what we're talking about right now with passwords and things like that. So that's great. Yes, ma'am. They are not. So, and that's why I'm kind of saying that I'm making this assumption of some of what I'm telling you is that you are single when you pass, because joint accounts are treated differently. When you're married, or if you have joint accounts, those are titled between 2 people. And so when one of you passes, the other one becomes full owner, okay? So in a situation, for most people, if they're married and a spouse dies, a lot of this never happens, what we're talking about, because the spouse just absorbs everything, just as they did it during life. So the checking account now becomes their checking account. The house becomes solely their home. Sometimes retirement accounts are even just rolled into the retirement account of the spouse. So it's a much simpler process when we pass and we have a living spouse. Okay, so now that we've talked about our non-physical assets, what I would also suggest is that when you get all of this information, that you put the information in a binder. The whole point here is, or a folder, you're kind of keeping all this stuff together. Yes, ma'am. That's true. Her statement was that it's her understanding that if your bank accounts are currently titled in the name of the trust, that you don't have to worry about any of this or a payable on death, and that's true. And the reason for that is that your bank account technically is owned or is, you know, the property of your trust. For if you have a revocable trust, you are the trustee, and so therefore you just manage your money the same way that you did anyways. But that's absolutely true, because even when you pass, the trust owns it, and your successor trustee is going to be the one to divvy up the proceeds or whatever has to happen there. So, okay, again, just to get back, compile all this information, start to gather the necessary documents, and again, just start keeping this in a pile that you're gonna kind of keep all together, and eventually you're gonna give it to someone in your family or your personal representative, okay? But along with that, keep your life because we didn't talk about this with accounts, but life insurance is also a very important piece of this, because for many of us, our life insurance policy, sometimes besides our house, can be our largest asset. You know, if you have a death value of $1 million on your life insurance policy, your family needs to know where that is, especially because I'm assuming with that much money, you intended for them to inherit it. So again, keep all of this information together. Third, assemble a debt list, okay? And by debts, I mean your mortgage, if you have loans or liens on any of your vehicles, if you have credit cards. Again, a lot of this stuff is handled digitally. We may never get a credit card statement in today's world, and in fact, some things are just taken out, electronically. So assemble a list of all of the debts you have, so that way your personal representative in your family will know, what obligations does my mom or my dad or my spouse have after they pass away. I want to be very clear, because sometimes this confuses people. They worry, or in fact, personal representatives often worry that they're going to be responsible for their mom's or their dad's debts. They never are. Okay, your debts stay with your estate. Nobody else kind of assumes those debts unless they're also listed on the account. So assemble all of this stuff, and then also include with that your homeowner's insurance and your auto insurance. Because some of us pay this monthly, some of us quarterly, some of us prepay for a year. But the last thing your personal representative needs is to be going to try to sell your house. Something happens, the house is damaged, now there's no homeowner's insurance because it's lapsed. So your personal representative needs to know, is your homeowner's insurance current? Is your vehicle insurance current? And they need to be able to talk to those representatives to know that. Now, unlike financial institutions that really fear lawsuits, and I understand why, your insurance agents might be willing to give out some of that information. Mom's paid through November, or dad's paid through, April. And so then they'll know to kind of what they need to do. Then, after you've compiled it all, after you have a good master list of everything that you have, I want you to try to consolidate if you can. Okay, now sometimes it doesn't make financial sense to try to consolidate. Sometimes it's not practical, so that makes sense, don't do that. But sometimes there's like 3 checking accounts out there. You know what I mean? There's 4 savings accounts, there's 2 retirement accounts. And so if it makes sense, and like I said, if it's fiscally responsible and feasible, consolidate those into one account. Okay, especially if you're getting the same interest rate or the same benefits through all the accounts, just put them into one. Because again, the goal here is to keep it simple. The less that your family has to manage for you upon your death, the easier it will be. So if you can, consolidate. And I'll give you a funny story. I once had a client, a husband and wife, and they had, and I'm not kidding, probably 300 bonds. Savings bonds. And they had bought, since they were married, they were buying like 15 a year. I mean, they were just kind of, and many of them had already reached the maturity. They've already doubled in value. And so it was just kind of thinking about whoever inherits those, that is going to be a chore, or if we have to transfer them, whatever. And so they actually made a decision to start all those ones that had completely matured, they were cashing them out. And they were putting that money, because there was no more value in just keeping them in bonds. And so that's just a simple example right there. I also had a client that we did a trust for who had 3 checking accounts. And so we consolidated them. And a lot of times, if you have a financial planner, and many of you probably do, a lot of this information you already know because your financial planners helped you kind of work through a plan. If you have, sometimes they'll give you a folder and a binder with all this information, the account information. Go ahead and put, you'll have a lot of that data and information at your fingertips after working with a financial planner. But if you can, consolidate, talk to a financial planner, see if it's feasible. And again, only do it if it makes sense. But sometimes it helps to simplify things. Okay, and then at the very end of all of that, after you've consolidated, after you've seen everything you have and you've made this master list, then I want you to double check that your beneficiaries, your TOD and your POD are all up to date. Now, a beneficiary, most of us know what that is because they're on our life insurance policies and our retirement accounts. A TOD stands for transfer on death, and a POD stands for payable on death. All 3 of these things work the same way. I think lawyers just make up words for different things, And so they all work the same way. The mechanism that they have, it's all the same thing. But what they basically mean is that whoever you put as that person, they get your money immediately. They don't have to wait for probate. They don't have to go through the court process. Whoever you put down to get your money, they get it. So by example, a beneficiary, and I will tell you this, they're called beneficiaries because they're contracts. And the person who receives a benefit, or a benefit is conferred upon a person in a contract, they're the beneficiary. So that's where you have like your life insurance and your retirement accounts. So you list that person, and you list maybe, you have your primary beneficiary and then your secondary beneficiaries. And so make sure those are up to date. Make sure nothing's changed. And this is a good indicator, is anytime there's a death, a marriage, or a birth, you need to start thinking, okay, do I need to change something? My daughter just got divorced. Do I need to change something in my, with all of my documents? Transfer on death is often when we're talking about title, because legally when we talk about titles, we transfer titles. So the title to your home, by example, the deed, that we can transfer to somebody else with another deed. And this is I think one of the most amazing things in estate planning. It's fairly new, and by new I mean less than 2 decades, but the law now allows you to, in your lifetime, with a deed, designate who you want to inherit your home when you pass away. And it can be 1 person, it can be 2 people, it can be 3 people. I have a case right now where there's 8 people, okay? That's a nightmare, but because they're spread across the entire United States. But so what happens is you go to an attorney, because I don't know of anywhere like Staples that you can buy a TO deed or a TOD deed, unlike sometimes you can buy like quitclaim deeds. But with a TOD, you can list on there who you want to get your house when you pass away. Then you file it with the Register of Deeds, and then what happens is that when you pass away, those people can automatically take title or ownership to your home. Now, they may have to refinance, they may have to do those types of things, but most often this is used as a tool to allow our family members to sell the house immediately without having to wait for probate, without having to wait for the personal representative. The other benefit to it is everything that goes through the probate system or the court process there's a fee that's attached to it, and it's 0.2%. So even if your home is valued at $150,000, for most people, it saves them money to do a deed to make sure that that house never goes through probate. Okay, I think most attorneys in this area, sometimes it's a flat fee of $75, $100 to do a deed, and then it's typically $30 to record it. But that's a way to save money if you know that you want your house to be transferred to somebody when you pass away. If you have a trust, you don't need to do this, because typically your house is titled in the name of your trust. So that's now we're through our second step, which is where you have the most work to do. Okay, I know we're at about an hour, so I don't know if we want to take a break or. Okay. You have a quick question? Yes. I'll answer this question because it's a very good one, and then we'll take maybe a 10-minute break and come back and finish up. Her question is, if you have beneficiaries, TOD and POD, is the ease of handling your assets that way the same as the ease that is with a trust? And it is. So a lot of times, if somebody doesn't necessarily need a trust, we can do through POD, beneficiary, TOD, these types of things, we can have the same benefit of avoiding probate as a trust would give you. Now, a trust is just one document that provides all of it, but I'll be honest, most times trust costs between $3,500 and like $6,000. So for some people, when their assets are not that great, or they don't want to spend that money right now, by doing a POD, which is free, a TOD on some of your investment accounts is going to be free. On your house, it's not, but it's minimal. And then beneficiaries, that also avoids probate completely. So it's an alternative for people to do a simple will, then do all of the POD, TOD trust, and it has the same benefit as eliminating probate has the same benefit as a trust would, because those assets transfer immediately. Okay, so maybe a 10-minute break. I do want to say, during the break, a gentleman came up and let me know about something called green burials. And this is something I've heard from a client before, but he and his wife, I believe, he and his wife actually have plans, and they're not going to be buried in a cemetery, but it's like a cemetery, and it is just a shroud or a pine box. And I did once have a client who wanted to go that route, and I know that she was looking at some things. So thank you for that information, because it is. Thank you. And so it's available. I don't know that it's as widely available as, you know, the traditional plans, but definitely do some digging. I'm sure you can look on the internet and there's some plans. And I do remember that part of it was people are concerned about the carbon emissions that when, you know, when they're cremated and the impact that that has on the environment. And so, and you confirmed that for me. So thank you very much. Yes, ma'am.
Is the Eugene and Linda Farley Center for Peace, Social Justice, Sustainability in Verona. And it's, you know, it's probably about like 15 miles from here. I was the board chair. And so Jean and Linda were also family physicians on UW campus. And so they donated their 49 acres. So part of it is the Peace, Social Justice Center. Part of it is the community gardens. And the other is the cemetery. And I think, you know, that, I think maybe, you know, that might be a good topic at some point, because the Green Cemetery is in the forest. So you would never know that there's, you know, that there's a cemetery there. Okay.
And truly thank you, because a lot of this is a dialogue, and that's why I want you guys to ask questions, okay? So I really appreciate that information. Okay, we have 2 more steps, three, but these ones are much quicker, okay? So now you've done all the heavy lifting. You've gone through the mental process, the emotional process of thinking about death and dying, what you want to have happen. Now you've accumulated all of your information, and now it's time to put that plan in action. So make an estate plan, okay? And I'll be honest, I can't go too much into depth with this, because this is an entire, I mean, we could spend hours just talking about the difference between trusts, wills, revocable trusts, irrevocable trusts, all of this. But what I will tell you is some of you probably have an estate plan, and that's great. Now, after you've done the hard work, just make sure it actually does what you want it to do, okay? If you don't have an estate plan, now's the time to get one. Basic, you know, you have trusts, which are one comprehensive document that takes care of everything. It eliminates probate. It costs more money up front to do it, but it saves you money on the back end. And the other thing about a positive about trust is it keeps everything confidential. Nothing goes through the court system. And so you don't have, you know, publication. You don't have some, you know, nosy little relative going, how much did Uncle Jerry have when he passed, right? So those are benefits. There's also sometimes some tax benefits. As you guys, I'm sure, are aware, you know, the estate tax changes sometimes yearly, depending on who the president is, you know. So, you know, I think it's 11 million now for an individual, was 5.32 or 23. But there were times where it was as low as $1 million. There were times where there was talk that there would, you know, it was 0. So again, that's just something, sometimes trusts are used because of tax consequences. A will is a document that you create, and that the purpose of the will is to designate who gets your stuff and also to decide who is your personal representative. If you have minor children or even minor grandchildren that you're caring for, it would be to list who becomes the guardian of those children. And again, that's a special consideration. Like if you're the legal guardian of a minor right now, just like if you have a family farm, if you have a handicapped child or a child who has a disability, that's something else that kind of requires a little bit more in-depth discussion than what we'll get in today. But so a will is always admitted into court, okay, or should be. Because a will is always subject to probate, which is the court process. It lasts typically about 12 months. That's the deadline that the courts say you have to, you know, you should complete the administration of this estate within 12 months. Sometimes it's less, many times it's longer, okay? The one thing to be aware of with probate is there are fees. And it ties up the money, okay? Because everything is kind of tied up in probate until the very end when those assets can be distributed. The other thing to remember about probate is there are different types of probate. This is why I say we could have an entire discussion on this. But there's formal probate, there's informal probate, there's 3 types of like special administration. And the type that is used is all dependent upon what your assets are when you die. And not just your assets, but your probate assets. So when we talk about using beneficiaries, PODs, TODs, those are not probate assets. Those are in this other little pile over here. But if you don't have a TOD, a POD, a beneficiary, then anything that's left without a POD, TOD, or beneficiary, that will go into probate, okay? If you pass away without a will, then your estate will be probated, so long as what you own as an individual is more than $50,000. So again, that is a very complex type of discussion, and hopefully, because we're here to say, here's what my personal representative needs, we won't care because we'll be dead, right? So they'll have to deal with that. So that's maybe that's why we don't have to go into the fine details there. But talk to an attorney. And I'll tell you the easiest way, I mean, for some of those formal documents, if you're looking at getting a trust, go talk to an attorney. A will, go talk to an attorney. If you need a TOD, go talk to an attorney. Those are the formal things that you can take care of. And I will say that as an attorney who practices estate planning, it is never beneficial to go into the attorney's office and start with, well, what should I do? Because I don't know anything about you, you know what I mean? So I want you to save your money and your time, okay? So I can help and say, okay, well, tell me about your family, tell me about your assets. But if you come into the attorney's office and you go, okay, here's what I have. Here's my retirement, here's my investment, here's this, and I have 3 kids and 6 grandchildren, and here's my goal. Then I can say, all right, let's talk about that. And then I can give you some of the finer details. Well, okay, so you want a grandchildren's trust. Do you want them to inherit that money at 18 or 35? Okay? And so we can talk through some of those details. But if we have to start that conversation and you've not yet thought about, oh, grandkids, I didn't even think about them, then it becomes harder, because now we're gonna spend 2 hours in my office and I don't wanna bill you for that. Does that make sense? So again, if you do that heavy lifting, if you do those mental exercises ahead of time, then your time spent with the attorney paying $200 to $500 an hour is a whole lot more beneficial, okay? So that's where, after you've done all that stuff that we talked about before, start to put your plan into action. All right? And then also, you can do some of those informal things on your own, the POD, the TOD, the beneficiaries. And so once you do that, and now once you have all of your estate plan formalized, get copies of everything and give it to your personal representative, okay? And you keep your originals in a safe place. Safety deposit box, so long as someone knows you have one, the lock box, the file cabinet drawer, but keep it all together. And then what I would tell you is every couple years, update it if you have to. But certainly when there's a death, when there's a birth, when there's a divorce, when there's a marriage, things like that, okay? So kind of keep on top of it, keep accurate notes. I would also caution you not to give a copy of your will to every child, okay? And the reason for that is you have the right to change it at any time. And so now if all of a sudden one child has like the will from 8 years ago and this child has the will from 3 years ago, now they're gonna be fighting over the wills, okay? Especially if one is more beneficial to the one child. So you want the freedom and the liberty to be able to make those changes. So that's why I say only give it to your personal representative, okay? And then again, keep a master list of everything that you have. And again, keep all of that stuff in the same place, but give copies to that PR, to the personal representative or your trustee. Yes, sir. So his question, if I'm understanding correctly, is he said, well, I'm a little bit cautious, or there's situations which I could be a little bit cautious in giving these documents to my personal representative, because they could also, look at the information, know who's getting what, and what if they are devious? What if they, what if there is a previous document that was more beneficial to that person? There is some truth in that, and I will say there's some situations in which that probably does happen, but to not tell them, you run the risk of them not being aware. And I have had clients where they have a copy of mom or dad's will that's never been seen, okay? But mom and dad have talked to them and said, here's my plan, here's my goal, here's what's gonna happen. So I do think that if you pick a good PR, if you've put in the time to say, okay, here's who I want to be my PR, and then you have that discussion with them and talk to them about what your goals are, what you want to have happen, they may never look at the will. But if they do, that's okay too. Or that risk is probably less than to never tell them anything, and now you have a whole other mess of problems on the other side. The other thing, I'll get right to you. The other thing I'll tell you is sometimes it's important, and this is actually number 4, so we'll lead right into this, is when you talk to your family, because you're going to talk to your PR, okay? But you also should talk to your family. And what I mean by this is I would suggest, and each of you know your families, so you know how well this will go over or not, but I think there's a lot of value in getting all the kids together and saying, I've chosen John to be my PR. And not you, Sally, or not you, Ben. I mean, don't say it like that, right? But, after a lot of consideration, this is hard, but I chose John because, for whatever reasons, he was more fiscally aware. I feel like he can handle the stress or, for whatever reason. And then let them know that John will get compensated. Because by law, he's allowed to be. There's a certain percentage of the estate that he's allowed to have for the hassle of going through and being the personal representative. Sometimes that does not sit well with siblings, okay? And so again, if you can eliminate that up front, then that's one other thing that nobody's bitter about on the back end. If you can talk to your children and say, all right, so here's what my goal is I'm hoping to leave something to the grandchildren. That way at least they know and it's not a shock when you pass away. Now you don't have to tell them all the details. You don't have to tell them how much. If they ask you how much you have in your estate, you may want to start to get a little cautious, right? But, let them know your general plans. Let them know what you hope to accomplish. Because again, this is the cynicism, but money changes people, okay? And as much as there's, for many of us, the angst and the sadness that comes along with death, there's also a lot of times that old bitterness comes out, old rivalries, old, all of these things that we've been harnessing since we were a kid. And, Sally's always been Mom's favorite, so of course Mom gave Sally the coin collection and blah, blah. That happens, And even when they don't get to my office because they're fighting about it, it happens even informally. I mean, it happens even when it's not a lawsuit, right? Everyone's feelings get hurt if they feel slighted. So it's really important to have those discussions. And I do want to get to your question. That's a good question. Her question is, who's an appropriate personal representative if you feel that an immediate family member doesn't qualify? And I hate to say it, there's no good answer. Because you could leave no one. You could not put somebody in your will as a personal representative, and then the court's going to have to assign someone. And I have seen this happen quite often where somebody has put a spouse in their will as a personal representative and never listed a secondary person. Well, the spouse had passed, and now somebody has to get something done with the house. And so what they do is they file a petition with the court to open an estate, and then they have to ask to be appointed the PR. But and this is where, when we talk about probate, the person who you nominate as the personal representative may not always be the personal representative. And the reason for that, it's just you're nominating them. It's just you expressing your wish. But by example, if I nominate my child to be my PR, and they have 3 siblings, and so, Johnny is going to go ask the court to be PR, but the 3 siblings don't agree, they can contest that. They can say, well, I don't think Johnny should. Johnny just filed for bankruptcy. I think I should be the PR because I'm an investment banker and this, you know what I mean? So again, just because you say it doesn't mean it'll happen. And that's, again, where your will may say one thing, but the talk you have with your family is more valuable. Because, again, it lets those discussions be had prior to the court system, prior to them, your estate being kind of drained because through the legal process. So again, that's where I say it may not be perfect, it may get a little icky, it may have some tough discussions, but I think it's better to have those discussions while you're living than to have your children have those discussions when you pass, and now everybody's assuming what you wanted. Everyone's assuming what you thought, rather than you just being able to say it with your own words. So that's why I do think that talking to your family is so critical. And again, not all the details. You don't have to tell them everything, but let them know your wishes, okay? And that, too, can be very hard because nobody wants to say, oh, great, after Thanksgiving, let's go talk in the living room and we're, I mean, these are not comfortable discussions, but it does have to happen. And I'm going to give you a very real-world scenario. I had a case in which a woman was the trustee of her own trust. and had nominated a daughter, she was one of 4 children, to be the successor trustee. And in the trust, at some point, years ago, she had changed the designation to where the one daughter got a larger percentage. Originally, it had been all 4 children would receive 25%. And at one point, the woman had changed it to where one of the children got 40%. And she never told anyone. And she didn't tell anyone why, but it was because that one daughter was her caretaker. And she lived with her, and she didn't work, and she did everything. I mean, all the doctor's appointments, everything. And so now we're in a 3-year-long battle. Yeah, because the other siblings feel that the daughter coerced mom. They feel that she had undue influence on mom, and that's where the coin collection. Remember the coin collection I said earlier? That's that case. But because, and now, I mean, in that, you would be amazed at the things that I'm hearing, and it's truly like, oh, she forced mom to go out and buy her car and take her to do her nails and da da da. I mean, it's just, and again, it's because the bitterness, all of it comes back from years and years ago. But if that, I mean, this is just where hindsight's 20/20. But I wish I could go back and just be like, tell them why, sit them down and be like, you may not like it, but I was of sound mind. I was a sound body. Nobody coerced me. Nobody forced me. And I made this decision competently, and I made it because of this. It would have eliminated, hopefully, a lot of these decisions. And so, I mean, I honestly can tell you I've had 12 cases like that in the last 12 months. And so, and what often happens is whatever money they're fighting about gets spent with legal fees. And that's the saddest part about it. And I'm not even exaggerating. I mean, I once had a case, this was 2 years ago, in which they were fighting over an absurd amount of money, but it really wasn't absurd with what each of the children received, but it was like $60,000. And amongst them, they spent over $85,000 in legal fees. And you want to know what it settled for? $6,000. So, you know what I mean? Like, it really, I can tell you, I know I do this for a living, but once it gets to this stage of lawyers, nobody is benefited. Nobody is. But sometimes those old arguments and that animosity is so deeply rooted that they're past the point of being able to settle it. And that's where I just say talk about it. If you are leaving things unequally, if you are leaving a valuable item to one person over the other, let that be known, and let the reason for it be known. Again, they don't have to like it, but at least you've heard during your lifetime, you've told them, instead of waiting for after you pass and then just letting them deal with it. Okay? And that's hard, but yes, ma'am. Yeah. Right. You're right, because I didn't answer your question. I know, all right. All right, so second time, she said, all right, Shauna, I asked my question, you didn't answer it, so what do I do? Who do I appoint as my PR? You can have the court appoint an attorney. Like sometimes, it can't be your attorney, okay? But sometimes the court appoint, like in Rock County, it's not unusual for the court to appoint an attorney at a reduced rate to help administer the estate. But honestly, if you don't pick somebody, and I'm not telling you that there's somebody to pick, okay? Because there just may not be. But if you don't pick somebody, you leave it open for anyone and their brother to come and ask. They have to be interested. They have to be like an heir of some sort, or you have to have left them something in your will. Or you just leave it open for the court to do it. No. You mean to be your personal representative? They absolutely cannot. That's a conflict of interest. So you can pick another attorney. Okay, so banks don't tend to do it. His question was, can you pick a bank? And the reason I'm assuming this question came up is because sometimes banks act as trustees, okay? But the reason for that is there's money involved. There's a lot of money involved. And so when the bank or financial institution or the bank, department asks as your trustee, they take a cut. Every year they take 3 to 5%, sometimes 6. And so you'll even find that a lot of trust departments and financial institutions will not agree to act as trustee unless the trust is over a certain amount of money. So I would imagine no. And the other thing you have to know is just because you pick a PR, they can decline. They can say, I'm not gonna do it. So there is no perfect solution in that. Sometimes somebody is better than nobody, you know? Otherwise, I would say I tend to, if you really are like absolutely nobody, then maybe you leave it for the court. Yes, ma'am. Sure, and what she had said is that she's had some situations with relatives who've passed away in which the PR was either a business partner or even a brother and sister. And is that reasonable? Absolutely. When I give you a generic situation, it tends to be spouses and kids. But that's not, I mean, that while statistically speaking, that's just kind of what happens, it's not unusual to have a brother or a sister, even a cousin. I mean, I've had situations in which cousins are. If you have a business partner, it's a long-standing business relationship, absolutely. What I would say is that pick somebody you trust, but also somebody who you feel is competent to handle the stress of it. There are protections in place through the court system, you hope, that this person has to act financially responsible. They have to be fiscally prudent, okay? And so if your financial, or if your personal representative absconds with all your money, there are mechanisms in place for your heirs to sue that person for breach of fiduciary duty. And fiduciary duty means that you have a financial responsibility, not to act as a, you know, as a broker or anything like that, but to use common sense, to be a prudent person in how you manage their money. And so absolutely, I mean, you just pick somebody, best case scenario, somebody you trust, somebody who you know is gonna be able to do the job. Second best scenario is you just pick somebody and hope they get a good lawyer. You know what I mean? But, yes, sir. But he said, is there a job description for a personal representative? No. Many times your standard will have a laundry list, like A through K, A through O, of like powers that they have. And those powers can supplement what's in the statute, but it's basically this wide discretion of authority to do whatever has to be done to manage your affairs. If you are a business partner, the PR acts in your stead. I mean, they do take over for everything that you would do, they now get to do for you. Again, you hope it's in your best interest, but as long as they do it according to what you've put in your will and in a financially prudent manner, I should say fiscally responsible, because prudent means different things for different people, you know, but that's pretty much all that's expected. Yes, sir. So what he said is that years ago he was told not to keep his will in a safe deposit box because it may not be immediately accessible. That can be true because, one, families sometimes don't know about it, but also you need to be that PR to be able to have access to it at times. Now, again, it depends on how that, like who has access to it, I'll say that. The other thing that people used to do a lot is to leave the originals with their attorney. I don't suggest that. And the reason is we're kind of past the days of where, you know, small town attorney handles everything in your family for generations and it's all in a box. I mean, lawyers are more transportable now. We go from this firm to that firm to that firm, and we're only required to keep certain documents for 7 years sometimes less, sometimes more. And so I have many times where people go, so the will was drafted by so-and-so, and I've called the wife, and they think they might be in boxes in the basement or the old storage unit, but nobody can find them. And so that's why I always tell people, you keep the original, and then let somebody know where it is, because the courts want the original. They'll take a copy, but it's not as advisable. So, hold on, I'm gonna, yes. Her question is, if you're donating to a charity, could you have a representative of that charity become the personal or be the PR? I don't see why not. There's no restriction as to who you can't have. What I will tell you though sometimes is that probate, the register and probate, they can get a bit finicky. I've had PRs appointed that were actually designated in a will and the PR said no, or I mean in the court said no. Or the court required that the person pay a bond because maybe they're a felon. Maybe they filed for bankruptcy in the last 3 years. And so there's reasons for, even though you trust this person, the court says, I'm not so sure. So there is nothing that says yes or no, but this is the beautiful thing. You can do whatever you want. You can put whatever you want in your will. Now, what happens after that point is sometimes, a little bit up in the air. But for most people, as long as you pick somebody who can act, that's who would be appointed. And especially if the only beneficiary of your will, or if the only person who stands to, inherit is the charity, I wouldn't see why not. Okay, so a couple more, yes. Perfect solution to that. He just said that he's added his daughter as a person who can access the safe deposit box just because of what this gentleman was saying over here. Yes. There is. I believe it's a $7 fee. And so what you do is you can take it and all you do is you go up to I typically start at the Register of Probate because they stamp it, they do what they have to do, and then they just keep it on record. Again, make sure you tell somebody it's there, okay? Now, there are times where if you call up probate and you say, hi, my mom passed, I need to file the will within 30 days, which is the law, but nobody really follows it because who would know if you're violating it, right? Sometimes you can ask the probate to say, hey, is there a will on file? And they'll check. Okay, but for whatever reason, that is not as common as I would have assumed. And it is like a fee. It's no more than $10 though. Okay, so I think we're almost done, but I do just want to just kind of want to wrap up with talk to your family. And the other thing, when I talk about anticipating conflict, that's why. Talk to your family, let them know what's going on, because you know your family better than anyone else. And so if you can eliminate that conflict while you're living, it's going to be better than having to have it when you pass. And so I do have a couple things that I would recommend. Okay, if it's appropriate for your family, I would strongly suggest that leave your estate equally to your children. Okay? I know, but there's a caveat to that, and I'll tell you why. Now, there's a couple exceptions. If you have a disabled child, okay, because again, the reason for that is that child, once they inherit that money, and if they're on Medicaid or any type of state aid, they will lose those benefits immediately. And then anything you left that child is going to be eaten up by the care that they receive, okay? There are exceptions to that. You can put that money into a special needs trust, etc. But that's an exception. Or if you have a child or family member that you would typically leave an inheritance to, but let's say they're very financially irresponsible, or let's say they're an addict or they're in prison, okay? Then those are exceptions. But otherwise, if you can leave your estate equally to your children, when you pass, it eliminates a lot of the conflict. Now, you probably are saying to me, but Shauna, I've given $125,000 to this one child during their lifetime, and my other child deserves to have more. That may be true, but start to gift it to that other child during your lifetime. Okay? Start to make those gifts if you can while you're living. Okay? Because nobody can argue with what you're doing while you're alive. Yes. Yes, he said, give with a warm hand, not a cold hand. I love it. I love it because your death is not a time that should breed dissension. It's not a time that should breed bitterness. And we don't do this on purpose, okay? But we're trying to be fair. And so let's say you've paid off $50,000 of one of your children's student loans. And it's only fair that the other child get the $50,000 the same way. Well, do it while you're living if you can. Okay, if you can't, let your children know that the money that you give to this child will be offset by their inheritance. I have a friend actually, was given $100,000 by mom as a loan, okay? Is it a loan? Is it a gift? How do we know? It's a good question. Because you want to make sure that your family knows, is it a loan? Does it have to be repaid, or was it a gift? Because what you say 10 years ago is very different than what your family's gonna allege when you pass. Okay? And so clearly designate the things that are gifts and designate those things that are loans. And I'm going to give you an example. I had a client, she had 3 children. One was very, very, very financially irresponsible. And she had helped this child out for years, had supplemented her income, had bought her a house, had done these things. Now again, not all of us are financially available to be able to do this type of stuff for our kids, but she had really kind of supported that child as an adult. And the second child would inherit the lake house, okay? The third child had always been, just kind of had her stuff together, never needed assistance, never needed help. And so, you know, my client's concern was, well, this isn't fair to the child that always had it together. It's not fair if they each get equal shares when I pass, because I've given unevenly to them throughout my lifetime. And that's true, and we do that even when our children are minors. Our children have different needs, right? But so the solution that we came about is when when my client's husband passed away, there was $1 million life insurance policy. And when she cashed it out, she had to cash it out. She had set aside a large portion of that life insurance policy to give to the child who she had never given to during her lifetime, because the child didn't need it. But again, doing it that way there's no complaints. Nobody can argue. I mean, they can try, but they can't sue the other, the two other siblings can't sue the child and bring him into court and say, well, you forced mom to do that in your will. No, because mom did that when she was living. Mom did that when she was competent. Mom did that when she was in charge of all of her faculties and when she was her own, representative. And so again, it's harder to contest it during your lifetime. And maybe that simply means you give, $10,000 a year, whatever it is. And again, if you can, equally distribute upon your death. It does avoid the conflict. If you can't, you can't. But if you can, just to be aware of that. Also, and then let the kids know if that's your intent, is to say, by example, this child's getting 40% because she's my caregiver. And then again, this is not the time to favor or punish. And even if that's not your intent, that is how your children will probably see that, is, oh, she's always been mom's favorite, or I knew mom was mad at me when she passed. And I always use mom because statistically speaking, mom will be the second of the pair to pass, okay? So yeah, use lifetime gifts if you can, just to evenly distribute it. And I did see a question. Yes, sir. Sure. So his question was, if you have one child designated as healthcare power of attorney, another as financial power of attorney, and the third as the personal representative, how are they compensated? Well, during your lifetime, if anyone acts as your power of attorney, and they actually act, okay, the law does allow you to provide reasonable compensation. Does not define what reasonable compensation is. But by example, if you're a live-in caregiver, and the going rate for that is $15 an hour, your child can be compensated at $15 an hour. They cannot be compensated for $60 an hour, okay? As a power, or as a personal representative, it's a percent of the estate that's probated. So that's just a statutory amount that they receive. And so a lot of PRs don't do it, sometimes they do, just depends. Don't accept it, don't even know about it, but but it's right there on the form. So I say, hey, you're entitled to it. But, and again, the last thing I want to stress is, if you have a family business, if you have a family farm, if you have a property that's always been the family's, like, some kind of vacation home that you want to keep in the family, if you have a special needs child, or if you are the guardian of anybody, a minor or an incompetent adult, those take some special planning, and I would recommend talking to somebody about that, because there are just some very specific types of planning that you have to do in order to make sure that those considerations are handled appropriately upon your death. Yes, sir. Yes, and in fact, most attorneys would suggest to do 2 or even 3. So that's always recommended. It's always best to have a primary and a secondary. Her question, and maybe I should defer not to answer this, but what's the legality behind where I can pass someone's ashes? I have to be honest, I don't really know, but there is a legal world and there is the reality, right? And I'm just gonna say that if you just happen to dump those when you're on the mountains and nobody's around, nobody would know, or if you bury them in your background or your backyard and nobody knows. So I mean, if you email me and I have a card, I'll look into that for you. But I don't, as I stand here today, know of any restrictions for that. But you may? Yeah. She just mentioned that, for some cultures that's frowned upon in this, and I'm assuming it has to do with, the afterlife and how people, in the Native American, there are some Native American tribes that don't, they frown upon spreading somebody's ashes. But that's a more cultural belief. All right, yes. So what he said is that he's heard, statistically speaking, only about 25% or 1/3 of parents actually talk to their children about the assets and then their estate plan, and he wants to know if I counsel my clients to talk to them. And almost always. But again, always talk to your PR, always, okay? And then if you have children that you think there's going to be fighting between them, and there's something in there that you think they would fight about, again, meaning unequal distributions, a gift to one child over the other, I would talk about that. Now, if you just have a standard estate plan where, hey, this is what's happening, and I've told my children or my family what I want for my funeral, and everyone's gonna get a third, great. You know what I mean? And if it's just really that's why I want you to start this conversation in your head with saying, minimize the work that my PR has to do and minimize the conflict between my heirs. If you don't think there will be conflict, now again, not all of us are reasonable at times, right? You know, we may think our children are fine right now, but just go into it with the mindset of, if you think there's going to be conflict, and if talking to them would eliminate it, it's better to have that conversation while you're alive than for them to try to, determine what you meant when you passed. So that's typically my advice. Yes. Sure. His question was, typically if you go through probate, how quickly can the PR have access to those funds, or the checking account, savings account? What happens is this: as soon as somebody comes forward to say, I want to be the PR, and then they have to petition the court. And there's a handful, half a dozen to a dozen documents that they have to file with the court. And one of those is to request to be the personal representative. Once that happens, you file them with the court. You have to send a copy to everyone who's entitled to have a copy. And then once it's approved, the court issues the personal representative something called domiciliary letters, okay? And then once the personal representative has those domiciliary letters, they can then go to the bank and transfer the money from, Susan Carter account into the estate of Susan Carter account. But that also requires an EIN number, okay, that you get. And so there's some work that has to be done. But the PR can act by paying bills, by, selling a house, opening accounts, closing accounts, once they have those domiciliary letters. Those are the letters that give that person the authority to act. And that typically, from the time of starting the process, shouldn't take more than 30 days. But it can. And again, that's because some people may object to somebody being the PR. There might have to be a court hearing. Other people have to agree and sign what we call a waiver and consent form. So it can be, but typically I'd say 30 days would be your outside limit. Yes, ma'am. I'll get right to you. Right, that's very true. She mentioned that sometimes, obviously one of the first things you have to do is get a death certificate. You need that for the courts. You need that to really do anything. And sometimes it can take a while to get that. Traditionally speaking, your funeral director will give you copies, 10 copies. You do pay for all of them. But, that's typically where people receive them. And I will say, though, sometimes if the death is suspicious or they don't know why, that can hold up the process of getting a death certificate, just like what you said, ma'am, if you died in a foreign country. Yes. Okay, she said she wants to, and thank you, because this is a very good point. She wants to name somebody who's the resident of a different state as the PR. That does get a bit more complicated. It's possible, but sometimes the court will require that they have a bond. It also requires that they have somebody in the state of Wisconsin who can sign for them. So it's like a resident agent, if my memory serves correctly. But it's a form that it's just 2 signatures are required. You nominated this person, the court appointed them, but they do have to have somebody in the state of Wisconsin who can act on their behalf. And the reason for that is more legal, is the personal representative is the person who stands in your shoes. So if somebody is going to sue you after your death by suing your estate, they have to serve you, and they have to serve, they have to be able to serve a physical person. And so that agent who acts in the state of Wisconsin can accept service rather than having to serve somebody across state lines, things like that. But yes, it is possible. It just becomes more complicated. All right, we are at the 12 o'clock mark, but I'll take one last question. Okay, so his question is, if you were to move to Arizona and you've been there for 3 years, does Wisconsin have anything to do with the administration of your estate? That is not a black and white question. Some people are dual residents. Some people are, they're snowbirds, which I'm assuming none of you are because you are here on February 20th. But some people are a resident of Arizona for half the year and can technically claim to be a resident. Some people are a resident, and then the other half of the year they're in Wisconsin. Some people own property in Arizona and in Wisconsin. And so sometimes you do have to go through a dual process. But if you've moved to Arizona and you're a resident of that state, which typically takes 6 months, or, so if it's been 3 years, certainly, and if you have no property left here, then it's Arizona that would handle your estate, the administration of it. So thank you all for staying. I know it's been 12.